Thank you, Chairman Rush. In his testimony, Mr. Black of the oil pipeline industry states that, and I quote, applying an ambiguous legal standard of recklessness will not advance pipeline safety. And Mr. Black would also have you believe, in my opinion, that requiring a prosecutor to prove that someone is both knowing and willful is standard legal fare, whereas in reality, most statutes require proof that someone is either knowing or willful, so rather than and or. So I wanted to ask Mr. Lesniak, is reckless an ambiguous legal standard, or is there a precedent in statute for holding someone accountable for reckless behavior?
Thank you. It's far from ambiguous or unusual. It's commonly used in other federal statute, and in fact, in most states, it's included in the Motor Vehicle Code and other criminal statutes. It's a common term in law.
And then doesn't the current hazardous materials safety statute contain criminal penalties for someone who willfully or recklessly violates the requirement of the federal hazardous material transportation law?
Yes, in fact, it does.
So I think this is neither novel nor ambiguous, and in my view, it would certainly improve accountability and safety. Mr. Lesniak, let me ask you another question. What do you think has been the holdup on the mandates from the 2011 and 2016 acts? Do you think that this is due to the duplicative and prescriptive cost-benefit required in current law?
Yes, it does. I think it is a big part of it. It's not the only reason, but it is one of the key reasons, and we need to get that addressed.
I mean, I think the statutory cost-benefit analysis clearly ties the Secretary's hands. So my question is, would eliminating it help prevent the extreme delays we've seen from occurring again?
Yes, we think it would.
All right, thank you. Let me go to Mr. Lesniak again about this mandamus issue. In the aftermath of the San Bruno incident, the city of San Francisco was blocked in court from forcing PHMSA to uphold its statutory responsibilities, and this happened because the court held that the law did not allow for mandamus-type citizen suits to be brought against the federal government. So, Mr. Lesniak, do we need the ability for citizens, states, and local governments to be able to compel PHMSA to do its job?
I think there's no question. You know, if you think the delays that we're seeing, that Congress gets frustrated with these delays with implementing the regulations, how do you think a community like San Francisco, San Bruno, Edison, Bellingham feel when they have incidents or they have pipelines in their communities that they have concerns about and they can't get PHMSA to act? Congress can hold these agencies accountable, but it may take years, if at all. And the public needs to have the ability to go to court to get these agencies to implement these regulations. That Congress is representative of the people. The people ought to have the ability to enforce the laws Congress passes.
Well, thank you. I wanted to ask you, you know, the industry, from their testimony, the Interstate Natural Gas Association seems, in my opinion, I mean, I'm putting words in their mouth, but from what I can see from their testimony, it's perfectly fine. They're perfectly fine with the status quo of rulemakings that take a decade or more. They seem to suggest we don't need to use modern technology like automatic or remote valves or smart pigs, and that we shouldn't review the integrity of pipelines that are half a century older or older. According to their testimony, a rulemaking process that never ends seems to be fine, and anything Congress might do to ensure faster results or improve pipeline safety and hold operators more accountable, and I quote, would overrule years of work in developing new pipeline safety regulations for gas transmission pipelines. But of course, what good, I mean, in my opinion, what good does it do the public to have a rulemaking process that goes on and never produces a rule? I mean, that's my problem. So let me ask you, do you think that the industry's opposition to new safety requirements is contributing to the growing opposition of landowners to having a pipeline run through their states, towns, and backyards? Because this is what I hear all the time. Is this opposition to these new safety requirements contributing to that?
I think it is. I think that the industry does throw comments and engage with the rulemaking process sometimes in a way that's counterproductive and slows down the process. And for some in the industry, I think it works in their favor, that they would prefer to preserve the status quo.
But then at the same time, you have this growing opposition from the landowners, and I think, you know, this only contributes to that. So I don't know that it's in their interest, but whatever. Thank you. Thanks so much.